Hi, this is Bob Miller over at Bob Miller Realty Group. Today we're going to try and cover lease negotiations in just a couple minutes. So the first thing to cover in lease negotiations and how it starts is with a letter of intent, or commonly called an LOI. And these are non-binding agreements that are put together so that the parties understand the basic outline of what's going to be involved in the major lease agreement. You might want to ask, well, why do this two-stage? Why do the letter of intent, and why not just negotiate right off the lease? And a good example of that why is you just want to cover the main issues with the letter of intent and not get into the minutia of a deal. For example, if you're talking about concessions, for example, you might have some free rent built in there so that to entice the tenant to do the deal. But in the lease document itself, you might want to claw back those free rent months that you're giving away in the event that the tenant vacates early or defaults in the lease. But you don't want to put that into a letter of intent. You don't want to make that a big issue right up front, but you just want to have the main issues. Or, for example, you're talking about rental increases. In a letter of intent, you're just going to say a one-liner saying something like, it's going to be CPI with a floor of 2 and a ceiling of 6. But in the lease document, it's going to take a full paragraph to say something like that. So if I get bogged down, the letter of intent is going to just spell out those things in the broad sense. So it becomes who writes the first LOI. From a tenant's point of view or a tenant's rep's point of view, I would suggest that you have the landlord or the landlord's broker write that first letter of intent, because there's going to be things that you're not thinking of, or they might not be negotiable. For example, getting back to the annual increases, or that's already built in. Let them go ahead and give you a letter of intent on full basis if they are willing to do that. If not, you're going to have to ask a few questions. These questions about the type of lease, the term of the deal, the rates, the size of the spaces that you're giving up, and the method of measurements. But it's always easiest just to go ahead and have the landlord issue that first LOI. It should spell out all of these things inside there, as well as a tenant improvement allowance, and who is responsible for doing it. For example, we're going to give you $50 a foot, but who is going to be supervising the general contractor? What time frame is going to be allowed to do those tenant improvements? Is it going to be repaid on a reimbursement basis or on a progression draw basis? If the landlord is doing it, that's fine. If the tenant is doing it, how long do they have to do those repairs? Those are things that need to be discussed in the letter of intent. As well as probably one of the most important things is who's the tenant and who's the guarantee, because the landlord is going to want to know the strength of that income stream when they move in there, and they're going to be far more flexible. For example, if the tenant is a large Fortune 500 company than it is if it was just a startup company that has no real guarantee and no strength behind it. And in the event of no strength behind it, there's ways of doing it. For example, just putting in a larger security deposit, and you can even have some of that security deposit be applied towards future rent as the lease ages out. But you want to know what the increases are and how they are being increased. When the commencement date is. This boils back down into the tenant improvement allowance, and when does all of those things take? How long is it going to take you to move in? How long is your employees going to be there? How long is it going to do the construction in the jurisdiction that you're in? So, sometimes it's different in one jurisdiction to the other. Some municipalities are easier to work with than others. What options are there at the end of the lease period, and what are the holdover periods? What are the insurance requirements? I've seen some of these leases that have really stringent insurance requirements. Other ones are a little bit more lax. But all of these issues, I suggest once you do have the lease, have it reviewed by a legal attorneys, depending upon the complexity of the deal, the size of the dollar. If you're just moving into something, you're taking it as is, and you're just putting up a security deposit, no guarantees, that's one thing. But if you're putting together a significant transaction with significant tenant improvements, I highly suggest you get legal review involved. There it is. If you have any specific questions, you can always give me a call. You can reach me at bobmillerrealtygroup.com. Look forward to hearing from you. Thanks.